Greetings to all. In 1986, the International Court of Justice issued one of the most consequential decisions, which is the military and paramilitary activities in and against Nicaragua, also known as Nicaragua versus United States, addressing covered United States activities in Nicaragua. In 1979, the Nicaragua government of President Somoza fell to a popular uprising led by the Sandinistas, who installed a new government, and almost immediately, armed resistance to this new government arose. The United States abandoned its initial support to the Sandinistas government when it learned that the Nicaraguan government was supplying aid to Marxist guerrilla in El Salvador. After that, the US began to channel money, weapons, and other supports to Nicaraguan oppositions known as Contras. In 1983 and 84, the US military personnel mined the Nicaraguan harbors and carried out attacks on Nicaragua facilities. Hence, in 1984, Nicaragua filed a suit against the US in ICJ, claiming that the US had violated the United Nations Charter and principle of customary international law. The Nicaragua asked the US to be ordered to cease its operations in the country and pay to reimburse. However, the US asserted that the ICJ had no jurisdictions because, among other things, they had issued reservations to ICJ's jurisdictions, which prohibit the courts from hearing a case involving the implementation of multilateral treaty. The UN Charter, namely Article 2, Clause 4, on the non-use of force was a relevant treaty in this case. On the other hand, Nicaragua argued that the court had jurisdiction since their claim against the US was based on the customary international law. While comparable in the content of UN Charter, it had not been suspended by it. So the issue in this case was that the United States violated its customary international law obligations not to intervene in the affairs of another state by training, arming, equipping, and financing the Contra forces, or by encouraging, supporting, and assisting military and paramilitary acts against Nicaragua. Also, the United States violated the customary international obligations not to use force against another state when it directly attacked Nicaragua in 1983 and 84, and when its efforts assisting the military and paramilitary results in the use of force.
I will be talking about the judgment of this case. On 1986, 27 June, the court had held the United States violated its customary international law obligation not to use force against another state when its activities with the Contras related with the threat use of force. The prohibition on the use of force is found in both Article 2, Paragraph 4 of the Charter of the United Nations in the customary international law. Due to a reservation made by the United Nations while accepting the court's jurisdiction, the court was unable to rule on the matters as it was related to multilateral conventions. As a result, the court was obliged to use its ruling mainly on customary international law and fundamental legal principles. Finally, in conclusion, the court held that customary international law finds its sources in the widespread consistent practice of states, where the court has said if enough states act in such consistent matter out of a legal sense of obligation for a long enough time or period, a new rule of international law is created. Because of that, this has prompted the court to explain in detail of how treaty laws and customary law with similar content can coexist. Furthermore, the court had looked into the existence and content of specific rules of customary international law, as well as whether an existing practice of customary international law was a rule. Now I will talk about how this is a source of international law. Although the rules of customary international law was applicable to a substantial extent, which was in terms of context for this case, mostly of treaty laws were not able to apply for this.
The fact of the asylum case. This case was happened between the Peruvian and Colombia government, where Victor Raúl Jaé de la Torre, a politician from Peru, has been held by the Peruvian government due to the instigation and direction of the military rebel on 3 October 1949. He has granted an asylum from the Colombia government, and the Colombia ambassador in Lima, Peru, has requested a safe passage for Torre to leave Peru according to the Article 2, Column 2 Havana Convention on Asylum of 1928 and the Article 2 Montevideo Convention on Political Asylum of 1933. While the Peruvian government did not agree with the Colombia ambassador by claiming that Torre was committed on a common crime instead of political crime, so both governments decided to bring this case to the International Court of Justice. The first issue of this case is did the Colombian ambassador violated the Article 1 Havana Convention on Asylum of 1928, which stated that the state to grant asylum, like the Colombia, is not allowed to give safe passage for persons under a common crime or deserter from the army or navy. Because in this case, Peruvian government is claimed that Torre is under a common crime. Secondly, should Peru as the territorial state be bound to give safe passage to Torre based on what the Colombian ambassador requests, although the Peruvian government did not agree to let Torre leave Peru? Lastly, the Colombia, as the government granting asylum, has violated the treaty law and the international law by unilaterally qualifying a criminal act for the purpose of asylum.
First, I will talk about the judgment of the case. According to primary sources of international law, the ICJ recognized that the scope of the Article 38 of the Statute of the ICJ contains of bilateral and regional international customary norms and general customary norms, just as it contains of bilateral and multilateral treaties. However, the ICJ also clarifies that the parties, the Colombian government, which grant about such custom, must prove that the existence of such custom was binding on another parties, the Peruvian government. On the fact, the relevant treaties that signed by the Colombian government have not ratified by the Peruvian government, as well as the asylum practice are not uniformly and continuously executed by all parties. For these reasons, it is sufficiently to prove that such custom is a generally applicable character and such custom is not sufficiently binding in the international law. As a proof, in the asylum case and the North Sea Continental South case, the ICJ fails to find such custom that meet with the standard, so the ICJ rejects true submission from the Colombian government. Next, I will talk about the judgment of the case contributes to the sources of the international law. The asylum case becomes a landmark in the public international law for several reasons. In the asylum case, the ICJ determines that the local customary international law does not exist due to the insufficient evidence. This indirectly indicated that the local customary international law may only exist in the specific cases. Moreover, in the asylum case, the ICJ eliminated the ambiguity in the diplomatic asylums under the international law. This promotes through the expansions of the political asylums law and the extradition law under the international law. Furthermore, in the asylum case, the international law has stricter regulations on the possible exceptions to the asylum law. These stricter regulations on the treaties law prevents conflicts with the stronger local custom in Latin America, which presumes non-interference in the internal affairs of the other country.
For the third case, I would like to explain about the fisheries case, which is United Kingdom versus Norway. The fact of the case, Norway passed a decree in 1935 that stated that specific fishing zones or grounds along its northern coast were strictly for Norwegian fishermen. The United Kingdom requested the court to decide if Norway had used a legally acceptable method in drawing the baseline from which it measured its territorial sea. The United Kingdom argued that customary international law did not allow the length of a baseline drawn across a bay to be longer than 10 miles. Norway argued that its delimitations method was consistent with a general principle of international law. Issue of the case. Problem arose in 1948 and 1949 when a large number of British trawlers were apprehended and sentenced. The British contended that Norway's boundary line was more than 10 nautical miles long, in breach of international customary law. The British also claimed that the baseline was inaccurate and deceptive. In response, Norway responded that they should draw a line according to the natural orientation of the shore. Norway stated that it was within rights to claim fjords and sounds, which is seas or huge ocean inlet, as well as territorial waters, citing the court's recognition of its history ownership of this region. Judgment of the case. The International Court of Justice (ICJ) found in that the fishery case on December 18, 1951 that Norway's claims over the maritime zone were in accordance with the international law respecting the ownership of sea area and implied that each nation had the authority to determine its territorial sea based on main criteria like geography, historical precedent, and economic need. Finally, the fishery case alludes to customary law, which is one of the sources of international law. This refers to the practice and laws adopted by Norway within the parameters established by the 1935 decree, which correlates their geographical and historical aspects.